So you want to know how to negotiate your own Virginia car accident case. You want to know how it works. You want to know the magic. Watch this video and see what we think. Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. And the reason you're watching this video is you want to know how negotiations work when it comes to your personal injury case. You want to know, perhaps, can you settle your case yourself? Maybe you've hired an attorney and you're wondering, are they doing it right? Or you want to have a better sense of how they're going to do it. Maybe you're one of my clients and you're wondering what I'm thinking about it, and you happen to come across this video. When it comes to negotiations, I will tell you that I think it's more of an art than science. So there's a few things that I'm thinking about whenever I'm entering into any personal injury negotiation. And what I'll say is, off the bat, negotiations in a personal injury case are like negotiations, in my view, in a lot of other circumstances, whether it's buying a house or a car, or trying to get a decreased bill on your phone subscription. At the end of the day, you're at one position, you want to get to another position. The counterparty is another position, they want to get another position, and you're both trying to come to a better situation for you both. So when you're thinking about that, there's a few things, again, that I think that you need to keep in mind. Now, first of all, 1,000-foot view, I think that you have to have a sense of what your case is worth. What do you believe the value of your case is worth? And when I say this, I also want to say it in an objective term. Now, when it comes to personal injury cases, we've written a good amount of articles on this. I've shot a couple videos on it about how to evaluate your own personal injury case. So that's not the point of this video, but I'll just say quickly, personal injury cases are subjective in nature, meaning there's no objective value to an actual personal injury case. At the end of the day, I think you need to, if you've got a complex injury case, you need to work with your attorney to come up with what you believe a fair value is for your claim, and have that in mind. And again, the details of that I'll leave for another video, or you can watch on videos we've done. But what I want you to think about when you're going into negotiation, and your attorney should be thinking about when they go into negotiation, is they have to have the value of that case in mind when considering where to start at. You also have to have a sense of what the walkaway number is. Now, you don't necessarily need to develop this when you start negotiations. A lot of times I'll have an idea of what I think the case is worth. The client and I have talked generally about walkaway numbers, and what a walkaway number is, what number you want to actually walk away from the case for, meaning what do you want to settle for versus what do you want to go to trial for. That doesn't necessarily need to be the number one step or number two step, but you need to have that in mind, because as you're working through negotiations, you need to be thinking about, well, what is it, the number that I get to that would ultimately make me settle this case? And the reason I want you to be thinking about that, but also the value of your case, is the next thing that you need to be doing is demonstrating that you're a reasonable actor. Because I think to engage in productive settlement negotiations, you, as one party to the negotiations, as one party to the dance, have to be a reasonable actor. Because if you're not going to be a reasonable actor, I don't think you're going to get into productive negotiations, and that will lead to one thing in personal injury, and that's trial. Which, look, you may have decided, I want to go to trial. The value of being heard by a jury, to me, is worth more than the money. And if that's your decision, that's totally fine. But you need to be clear in your mind about what you're doing, and not expecting to have an unreasonable negotiation from your end and then expect the other party to act in kind. Now, when you're reasonable, negotiations of personal injury are like other negotiations, at least in my view, and in my style, is to open the demand. We at Abrenio Law, we typically will put a demand out there to start negotiations. I've heard other people, other attorneys will just essentially give the information to the insurance company and say, hey, what do you think? I like to be the opener, because it just feels like I have a better sense of control. Also, I can demonstrate from that initial move that, hey, I'm going to be reasonable. And what I mean by reasonable is, I want to be clear, in negotiation is like any other negotiation. You don't want to just put everything on the table at once. I think you go higher than what you think the fair value of the case is, but not so high as to signal to the other party that you're being unreasonable. Now, this is going to differ depending on each case, and the numbers are going to be differ. But what I'll say to you is, if you've got a case that you think that the parties, you and your attorney, or you think that's worth $100,000 from a reasonable standard, opening up with $1 million demand probably is not going to get you there. That'll, in my view, demonstrate that you're not being reasonable, and that will be a non-productive negotiation. Now, on the same token, on the other side of the coin, in order to get engaged in productive negotiations, you need a reasonable actor on the other side as well. So that means that the insurance company, the adjuster, or the defense attorney, in order to actually have a productive negotiations to possibly get it settled, they've got to demonstrate to you that they're going to be reasonable as well. So how this works out in our context is, I will make an opening demand. We'll then wait for their response. Once that comes in, I will look and I will have a better sense of, okay, is that real money on the table? Is that something to consider versus they're just playing games here? It's not worth further negotiations. Now, one of the things that oftentimes will happen is I will make an opening demand that's obviously higher than what we would settle for, and the insurance company will then come back and make a demand, and the client will interpret that as a lowball offer. They'll have a sense of, I'm offended by that offer. That there's no way that I'm going to settle for that. What I'll say to people is the response, the first counter to a demand, is instructive to me solely because it shows me, are they there to play ball? It may seem like a low ball offer, but what I tell people is the second, third moves can oftentimes produce more information than that first move, because if I get a low ball offer and then I make a demand reciprocal to that, but I'm moving, and then they make a reciprocal response to that and they're moving too, as long as we're making productive movements, at the end of the day, all I care about is, what is the final number? Is the final number representative of something that makes the client happy, or at least we come to an agreement that it's productive, that it's a good result or a relatively good result? And the question is it enough money ultimately that makes trial not worth the risk? Now, whether or not a negotiation will involve 1 step, 2 step, 3 step, 10 steps, it really depends. Sometimes I've worked with adjusters that I know very well, and I know that they're going to be somebody that we get to it straight up, and there's only a few moves, and then we put the numbers on the table. And so long as we've built respect with each other and we can understand, hey, look, if you don't accept that offer, I'm going to go to trial, or hey, look, if I don't accept their offer, they're not coming up with other offers. If we've built that rapport, then it's much smoother negotiations because we work with each other, we know each other. Same token, sometimes I understand that the adjuster is one that wants to move multiple times to get to the number. But again, all I care about is what the final number is, and it's something that makes sense. But if through that period of negotiations we demonstrate, or they demonstrate, that we're not going to be productive, then again, personal injury cases are pretty straightforward. You just file a lawsuit and you march towards trial. And that's what I really like about personal injury, as opposed to like buying a house or buying a car. In those contexts, if you can't come to an agreement, both parties just walk away from the table. In a personal injury case, we can force them to trial, and then we can see if we can convince a judge or a jury about what the value of the case is. So we always have that backstop. Now, let's say we're getting to numbers to where we're getting close. The client thinks it's a decent number, but or maybe you think it's a decent number, but you think you can probably get more at trial. Another thing that you need to be thinking about is the cost of litigation. And what I mean by that is not just the tangible cost of paying for the attorney's fees, paying for court reporters and expert witnesses. You also need to be thinking about the risk, the value of risk. So money in your pocket today, guaranteed, can be a huge difference than a risk of higher number at trial. Because when you go to trial, there's always a chance you could lose. There's always a chance a jury could get it wrong. There's always a chance your expert witness doesn't show up. So let's say a case is worth, you think $75,000 at trial, they're offering you $50,000, but then you're going to have to pay $15,000 of litigation costs, but you have a certain $50,000 settlement value. It may be one that even though the number at the end of the day doesn't make sense, it's not as high as you want it to see. In my view, you should be thinking about what is the net dollars in your pocket. Okay, I'd rather you see more money in your pocket with a settlement rather than going to trial and seeing less numbers in your pocket. So if we decide to go to trial and let's say the offer is $50,000, we get in front of a jury and then they say it's $50,000, that in my view is a loss to you because you've likely spent money on litigation costs and that means money out of your pocket. So always be thinking in mind, in addition to what is the proper value of your case, what is actually going to be netted in your pocket. So that's kind of the way I walk through things when I'm working with clients in negotiations. I'm always going back and forth with them. I'm keeping them informed. Keep in mind, in Virginia at least, but I think this is just as a practical matter, even if you're being represented by an attorney, you're ultimately the one that gives authority to settle a case. Whether or not you're doing it yourself or you're working with an attorney can't decide for you what number is the value of settlement. So that's the reason I like to keep my client involved. That way they're making decisions with me. Sometimes they'll give me authority up to a certain amount, or sometimes we'll be working in lockstep. It really just depends on the client and what I think the needs are on the case. So hopefully you found this interesting and useful. If you're trying to settle your own case, of course, this isn't meant to be the 100% guide as to how to get that done, but really just my own philosophy on how I think settlements and negotiations work. So hopefully it's useful. If you have other questions, feel free to reach out to us. You can also check out the website, www.abreniolaw.com, where we shot a bunch of videos, answered a bunch of questions about Virginia car accident cases and other legal issues. So best of luck. Take care.